Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Content warning. This episode includes discussion of the murder of 2 girls.
You know that on the Murder Sheet, we love to talk to guests with experience in the world of criminal justice. Well, today, we'll be speaking to a highly seasoned Indiana criminal defense attorney, Mark Inman. He's got years of criminal defense experience. He was one of the defense attorneys on Indianapolis's infamous Richmond Hill explosion case, and tried that case in front of Judge Francis Gull. He's even argued before the Indiana Supreme Court.
We're beginning his thoughts on the latest happenings in the case against Richard Allen, as well as other related issues.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is The Delphi Murders, an experienced criminal defense attorney on Delphi, the death penalty, and deals. Mark, to start off with, just tell us a little bit about yourself and your legal career.
Still practicing a little bit, but not much. But I kind of always wanted to do criminal law. One, my grades weren't good enough to get hired anywhere else. And I always wanted to be in court. So I did about 40 years. I started practicing in 82. Always pretty much had a public defender contract or position of some capacity throughout that 40 years. At that point in time, there were a lot more part-time public defenders. And so you could do a part-time contract and then have a private practice as well. I had different partners over the course of time, but for the most part, and some great lawyers that I practiced with that helped me out in many ways. They knew more about the community, knew more about the judges, knew more about the courthouse. But I had my own, private clients, and they were mostly in state court. And then I kind of shifted over later on and did a lot more work in federal court. I was on the board of the federal defenders. That's when we hired Monica Foster. So that was about 11 years ago, who's now the chief defender here in federal court. And I did a lot more public defender work and cases over there. And I've done several death penalty cases. It's all been pretty good.
What's it like to do a death penalty case?
I'm just a boy that can't say no, kind of. So when I was called and asked to do it, you've got to maintain your summary rule 24 qualification. I mean, it's nerve-wracking. I think you have to realize that the death penalty wouldn't be filed if they didn't have a substantial amount of evidence against your client. It's not always the selection process for the death penalty cases is so arbitrary that that's why it shouldn't exist. But once you get asked to take that case, either by a judge or by whoever's in charge of putting together a representation for that client, then it makes you a little nervous. It makes you anxious. You don't want to lose. You don't want to do anything wrong. I mean, you know there's going to be some heightened scrutiny. But I was fortunate once again to be able to work with people who were more experienced. Because, you know, you can't take it. You're not supposed to be lead counsel on a death penalty case unless you've been second chair once. So someone can kind of help you and walk you through what you need to do and how you need to handle it. And I was fortunate to do death penalty cases with like Bob Hill, Brent Westerfeld, Andy Borland recently. And then we had a great team of investigators, especially Jan Dowling doing mitigation, and Bob Fisher and Larry Atwell doing some fact. But the fact is, once you start doing it, you can put a team together, you relax a little bit, you map it out. And the irony of the death penalty is that if you can negotiate a life sentence, you've won, kind of, right?
Mm-hmm.
If, for instance, in the Delphi case, there's no death penalty filed, so there's really no bargaining point. I mean, that's the irony of the death penalty. It gives you something to bargain. And I had to try one death penalty case. That was nerve-wracking.
Are you surprised that Delphi is not a death penalty case?
Well, when we first talked, I just assumed it was because of the attention and because of the appointment of the two lawyers, you know, right from the get-go. I think it's smart that it's not a death penalty case. From a resource standpoint, just from a pure resource standpoint, the county that files the death penalty case takes on incredible financial obligations, which Carroll County has anyway, by kind of treating it like a death penalty case without filing the death penalty. I think it's smart not to file death penalty on someone who, if sentenced for 2 murders, is going to serve what amounts to a life sentence.
Mm-hmm.
So, I mean, it's not worth it in many regards.
Right. That makes sense. And would there be, like, in a case, the way a case is structured or the way a case looks, would there be other reasons to not do death penalty and take that off the table?
To never file it?
Yeah.
Well, I mean, I think there's all kinds of considerations. Well, I don't know how a prosecutor makes a decision to file a death penalty case, to be honest. I think a lot of it's very arbitrary and very, I don't want to say knee-jerk, but, if a policeman's killed, they're pretty much going to file it, right?
Right.
You got to have a good case if you're going to file it. But then how you pick whether, and of course there's statutory aggravating circumstances that the case has to qualify for, but many of them do. I think the filing of the death penalty is much more of a practical consideration. Morally, no one likes seeing people get killed, and morally, you can believe it. You can believe in the death penalty or not. Doesn't really matter.
Mm-hmm.
From a practical standpoint, you have to figure out what it's going to cost you and your office, your staff, all the other agencies involved, and whether it's worth it. And I don't see ever coming out in this day and age on the side where it's worth it.
That makes a lot of sense, especially one so high profile.
Yeah. I mean, I don't know, like Timothy McVeigh, bombed the federal courthouse downtown or something. That might be a little different, but once again, where do you draw the line? You never know where to draw the line.
Right.
So that's always been my view of the death penalty. From my standpoint, I mean, I don't like it morally. I don't think it solves anything. It's not a deterrent, but I think you have to be practical about it. And when you're practical about it, you have a real reason not to do it. And like I said, the only irony is that it gives you a bargaining chip.
And as you say, the death penalty is not on the table in Delphi. So is that going to make it harder for a potential plea bargain in the case?
Sure. I mean, what incentive does Alan have to plead guilty? They're going to give him a 20-year deal? No. And I've had many cases where myself that have been serious to middle-aged people, even younger people, and my argument has been, I know it sounds like a lot of time, but the question is whether you want to die in prison or not. And I'm giving you a deal where you won't die in prison. And you can't give that deal to Alan. So I'd be shocked if there was a plea agreement.
Now, of course, there's so much going on in this case. We don't even know who his attorneys are going to be. Can we talk about this situation? I mean, what do you make of some of this?
We've talked a little off record before about it. It's just,
how weird is this situation regarding the original defense team and Judge Gull? In your view, with all of your experience,
like from 1 to 10,
yeah,
9.99, I suppose.
Have you ever seen anything like it before?
No. When you're a PD, when you're a public defender, you will, if you do it for longer than a month, you're going to have a client who wants to get rid of you, either because you won't present some ridiculous alibi or you won't depose 50 witnesses on a level 6 felony, or you won't do what they want done, or you're saying, look, they've got you. You've got 3 felonies on your record. They're offering you a year. It's a good deal. No, I won't take that. I want to go to trial. I want another lawyer that'll work for me. Complaints, in other words, right?
Mm-hmm.
And so, or someone might write a letter to the court. In federal court, they're much more formal about how they do these things. And, I've been on the side of several of these where you have a hearing to determine whether or not you should remain as his or her attorney. But I've never had someone write that, I don't know Mark Inman, but I've heard about him and I really, really want him as my lawyer. Right? So that's my public defender, right? I mean, you can hire whatever lawyer you want, and this idea of the right to be represented by whoever you choose really is twisted around here from a public defender standpoint. So I got ahead of myself, so if you have a hearing, you go in and the prosecutor is not there. This is the one thing that I think we talked about before was, should the prosecution really have any say or any position on who represents Alan or who represents anybody? Because when Mary Smith wants to fire me, then Mary and I go in and the judge says, well, Mary, what's going on? And she says, well, airs her complaint. You can't take it personally as a lawyer. Many do. You can't take it personally. You might have made a mistake somewhere, but it doesn't mean you can't rectify it. Like, no, Judge, I haven't visited her in a while. That's my fault. But I've been working on the case, been over to talk. We're okay now. Half the time I'll get solved that way. Or the judge may say, is there a complete breakdown here? And sometimes the lawyer will file a written motion saying there's a complete breakdown. And then the judge says, okay, half the time I'll say, Mr. Inman knows what he's doing. You don't get to pick your public defender. He will continue on the case. You guys need to kiss and make up. The other half the time, you may be gone and another public defender comes in. But the point is, you don't get to choose your public defender in the context of that hearing. That's what makes this so unique.
I think some people have expressed the concern, and I'd be curious if you think this is legitimate or not, that if it becomes easier or if it becomes even possible for judges to dismiss someone's defense attorney, whether it's a public defender or whatever, that's basically giving the judge a veto power over what defenses are offered. Because in theory, a judge could say, oh, I don't like this defense. You're incompetent. You're off the case. Is that a legitimate fear?
Yeah, I mean, I can't say it's not. I don't think that this sets a precedent that judges are going to view as giving them carte blanche on who they can let go or retain. But having said that, in the interest of caution, you really don't want to see it happen if you can keep it. Now, the court's concerns, half of the court's concerns in this case, from what I can tell, were more almost, ethical or professional responsibility violations, having to do with the leak of the photograph and the early release of a press release that just jumped in the face of the gag order or something to that effect. Am I right there?
Definitely with the photographs. I think the gag order came down right after the press release was put out there, but I believe what Judge Gull is citing there is that there were conversations with her where, we're not going to try it in the press. Next thing she knows, there's a press release out there. It seems like there's a breakdown between, as far as Judge Gull cites, between the original defense team and like her faith that they're telling the truth.
Given that circumstance, I think she has the power to address that.
Right.
And needs to address that.
How important is that? I'm curious. I want to drill down on that a little bit, if you don't mind. The importance of trust between the parties and the judge, and
it's 100% from where I'm coming from.
Right.
My thing about practicing law for as long as I did was, I wasn't the best trial lawyer in the world, but I maintained good relationships with judges, prosecutors, other defense attorneys, whoever. And you do that by keeping your word. That when you go back into chambers trying to diffuse a difficult situation or to go back and lay out to the judge what both of you are trying to do in a professional manner, that you're going to go into open court and you may argue this, you may do this. So the judge doesn't get surprised every 15 minutes in court with a shouting match between the lawyers. But you have to say, okay, we're going to do this, this, and this. When we leave the chambers, we're going to do this, this, and this. And then you have to do that. You have to trust each other. Now, you can't practice that way everywhere with every judge or every attorney. And there are some attorneys who just don't even bother doing that, and they want to be completely adversarial all the time. And that's their call, but that was never how I did it. So I think it's very important. And having tried a case with Judge Cole and being in, a very important case, that Richmond Hill case, and being back in chambers with my co-counsel and with the prosecutors, I know that we had a couple of meetings back there that there weren't anything super, super secret or anything like that. It was just, this is what's going to come out. This is how we think it's going to come out. This is how we want to do it. Is that okay? Streamlines the trial. Let's do it, right?
Right. In your experience, was she biased against the defense attorneys, against you in that situation, or did you feel like she was even-handed?
The whole world was biased against us.
Yeah, fair. But did you feel like she demonstrated a more favorable attitude towards the prosecution, or did you feel she was pretty even-handed as a judge in that situation?
No, I think she made a couple of rulings that she could have thrown us a couple of wins to help ease us. That really wouldn't have affected the ultimate result. I think she made but judges make bad rulings. Lawyers make bad arguments. I mean, it happens. That trial was so lopsided anyway. I mean, she couldn't have made it any more lopsided. So she didn't have to. She knew that. Right. She knew it was, I don't know I think it's been through appeal and post conviction, and it's not going to get overturned. No, it was fair. It was a little different situation, but still, I never felt that. Every judge has a reputation, right? I think at that time, her reputation was that she's somewhat pro-prosecution. But how many times I've heard that about judges? I mean, half the judges are we're prosecutors, right?
Yeah, right. I imagine a lot of that has to do with where the judge came out of being a defense attorney or being a being a prosecutor beforehand. It's going to influence your perspective.
We had a loser from the beginning, and Ted Minch was the attorney that did most of the work on that case. I was second chair. did a phenomenal job.
Yeah.
And the state did a phenomenal job. And I think that made it easy. We knew the prosecutors because we had dealt with them before. We knew how much work they had put into putting the case together, and how they tried to streamline their presentation. There were only a few things that we could challenge, and so it made it. And she didn't get away at that. Her job, the judge's job, many times is not to get in the way of good lawyers trying their case, right? Now, whether that's going to happen here or not, I don't know.
You keep on talking about what a lopsided case that was. I don't mean to go off on a detour, but I'm just curious. What's it like as a defense attorney to get up every morning and go to court to litigate a case is not going to go well for you?
Well, you just say you know what your spots are. You can't. You have to kind of put out of your mind not what's at stake, but what happened. You almost have to be a little scientific about just picking your spots. Know what you're going to do that day. I know I've got to challenge their expert after these two witnesses. I'm doing the best I can, but I know what the verdict's probably going to be. It's not to me, and there are a few that aren't like me, but it's not a win at all costs that. And it's not a matter of I've never lost a trial before. I mean, I don't buy that from anybody. If you have never lost a trial before, then you've never really tried some public defender cases that are pretty lousy. So
yeah, you're cherry picking in that situation.
Yeah, right. Yeah. So, but that was like, Kevin, I heard a quote years ago when I was younger. It's like, it all balanced out. When I was young, I lost some I should have won, and when I was old, I won some that I should have lost. It's called the gray hair factor, I think. I just think you have to be objective about what your chances are, or you're going to be telling the client stuff and giving them false hope that you maybe shouldn't be doing.
One question I have, kind of going back to the possibility of having a judge essentially fire the defense team in this case, setting a bad precedent. But I'm going to flip it and indicate, so what we know is that the defense team told Judge Scull that they were going to recuse, and then they kind of turned around and indicate that they were strategically not telling the truth there. Would that be a bad precedent to set if Judge Scull is removed, that, parties can essentially weaponize lying?
Well, yeah, I think so. I mean, and from what I can glean about what happened back in Chambers, in the end, she said, I mean, to cut to the chase, she said, look, you can either withdraw back here or I'm going to lay you out in open court. I mean, to me, does that make sense to you?
Yeah, that's sort of what I'm reading.
And they decided that they didn't want to get laid out in open court because it might hurt their reputation. I don't know.
Yeah.
I mean, that cannot be the deciding factor if you're representing somebody,
Right.
And they tell the judge they're going to withdraw, and then they go out and say they were strong-armed into withdrawing. If you felt you were strong-armed into being withdrawn, then put her feet to the fire and make her make the record, and then walk out of there with your head up high. Not, that's what you do. If you're afraid of getting laid out by a judge as a defense attorney, you ain't gonna last long.
Yeah, it's
I mean, that's the way I look at that. Now, it's like, I don't know, everybody's right and nobody's wrong in that old line from a song. It's just everybody's been put in such a weird position here that I don't know that there's been any precedent for what they did. So, but back to your point, if you're back in Chambers, and you say, Judge, I'm not going to call witness X, or I just have a few questions on cross-examination for their witness, and then we'll be done for the day, or whatever. You stick to that. Either that, or don't go back in Chambers and talk to the judge. So,
Yeah, it certainly speaks to a general breakdown in trust, and certainly I think that no matter what happens, we can agree that both both the judge and these old defense old defense attorneys cannot stay on, because that would just be a disaster going forward. I'm going to ask you to do some crystal ball gazing, if you don't mind. What what do you think? And obviously, we don't know. I'll lead into the crystal ball gazing. We'll ramp it up to that.
All right, good. Yes. Yes.
My question is, to start off with, are you surprised that the second writ of mandamus was granted an oral argument, or oral, the hearing with the Indiana Supreme Court? I think some people that we talked to thought that that would just be dismissed outright, but is it are there any tea leaves to read into what the fact that that was actually granted a hearing?
There was would you say second writ? I don't know which first.
Oh, sorry, the one that she should be thrown out.
Okay. I think, given the uniqueness of the case, and just given all the convolution, I think it in a way it's smart for them to set it for oral argument and just let everyone air this out, because it is so unique. You don't have a lot of precedent, like the briefs that were filed. As far as case law is concerned, cases where a judge has removed lawyers that a client wanted are few and far between. Right? I mean, the Supreme Court is to rely on precedent. I don't think they have a lot here. And I think in part that's why they want to hear from people. I think they understand that it's gotten a lot of publicity. I think it's great that this is going to be aired, and what all of their arguments are, but that everyone's been made aware of that and to be able to watch it. All your listeners, if they're interested, it's right there for them to be part of the public. Why hearings are in public. Mm-hmm. And as far as the other, so I think it's a good thing, and I think these are very difficult subjects to brief, to be honest, and an oral argument will help flush them out. As far as the other writ being granted, I think a lot of it took care of itself as far as the records being released. And I think the court said that a lot of this was moved because a lot of the problems had been solved, and in no small part to the work you did.
Oh, thanks.
Well, I mean, it's true. So yeah, I'm anxious, not anxious, but I'm kind of excited to watch it. I think it'll be a shit show, but I think it'll be fun to watch.
Yeah, I think that's a pretty good.
I mean, like, are they going to line up in corners and no, but the court, to argue a case in front of the Supreme Court, and I've only done it. I think I've done it twice, actually, in Indiana, and I've argued in front of the Seventh Circuit Court of Appeals. But, it'll be, and I think all the lawyers involved have argued more than that. I think that the court is they're not going to just yell and interrupt and ask questions. They're going to interrupt and ask questions. They're going to be polite about it, and they're going to be curious. They're going to have done their homework and know what they want to talk about.
What was it like for you to argue before the Indiana Supreme Court?
I don't remember. I was in a fog the whole time. No, it was an early death penalty issue, actually. And it was a very specific point. And I don't even know if any of those justices are still alive. I mean, this was 35 years ago. They were very polite to me. Some of the Seventh Circuit judges aren't the same way. But, the point was made. We had a half-hour argument. Once I got started, it's just like, you just start going. And the thing about standing up and talking and arguing is that time goes quickly, right? I mean, I don't know that we didn't have an hour argument. I think we probably had a half hour, maybe 40 minutes. It went fast. Once you're up there, you start going, it goes fast. So.
Generally speaking, how is it different from a standard trial experience as far as like the skill set that you're deploying as an attorney, and just, painting that picture for the audience that may not be so familiar with those kinds of arguments?
Well, I think what your listeners or people that are not familiar with it need to understand is there's no evidence, right? You're not questioning witnesses. So it's a little more theoretically intellectual. Well, you've already submitted your arguments in briefing to the court. The court has the transcript of all the evidence and exhibits and everything else. And so you're focused on a much more specific topic or topics, depending on what you've raised. And it's not a question of innocence or guilt, although one issue is whether the state had actually proved their case, but that's rare that you're ever going to win anything on that. It's more technical, it's more specific. And you get to argue more like, what the Constitution protects in the criminal case, for instance, what the law should be. You get to argue more on a philosophical, constitutional basis, which is kind of nice in a way.
Yeah.
And then they throw some hypotheticals at you, and you got to be ready to handle it. You got to be able to think on your feet. But as far as what's in front of that court, for whoever's watching that may not have ever watched that before, the court's going to come in there with some questions in mind. They're going to have met. They're going to have talked about what they want to find out. They're going to try to direct the lawyers, steer them in that direction. They may ask, like, why? Once again, this goes back to something we started talking about 20 minutes ago. I'm curious as to how they're going to handle the question of whether the state should be involved in the selection of an attorney for a defendant. It's not that the state made a motion to disqualify them, right?
No, they did not.
And it's not like they jumped in and said, well, judge, don't get rid of them. We want them to be on the case. They don't have a position here. Who represents the defendant is not the prosecutor's call, nor should it be. So I'm just curious how they're going to handle that.
Right. Yeah. Our understanding is that on the early call, when the defense was alerted that they were in trouble, essentially, Nick McClellan, the Carroll County prosecutor, made a statement like, I think they should be taken off the case. And the judge responded affirmatively to that statement. But there's been no, as you said, there's no record.
Yeah,
no
I just
filing.
thought that's not his call.
Right.
The judge, it doesn't matter what he thinks. Right.
Right.
Maybe, anyway.
So it's kind of a reach, and maybe will cause them problems within the hearing. So here's the crystal ball question. What do you think's going to happen? Is the judge gone? Or is the defenders gone? Is everybody gone?
is there a betting line on this? Somewhere?
Yes. We're the bookies.
Not on FanDuel yet.
No, it's not.
Oh man. All right. You want me to make a guess? I know. Let's put it this way. I think it's 65-35. The attorneys stay on. The judge goes. That's my breakdown, because who's more dispensable here in a way, right? From the standpoint of ineffectiveness at this point, if Alan is saying that, I'm brainstorming here. I'm just trying to think. If Alan comes back after he's convicted and says, I was denied the right to have these attorneys talk about Odinism or whatever he wants them to do, it's more likely that it's going to be overturned on appeal than it is if Judge Gull or Judge Jones or Judge Smith. Doesn't matter who the judge is in a way, right?
Right.
So to me, from a once again, I'm resource driven sometimes, I guess, on these. It's going to save a hell of a lot of time in the end if the lawyers stay on.
Follow-up question on this, and this might be drilling down too far, but do they stay on as public defenders and get paid by the county, or is their initial request to come back as pro bono granted?
Well, I mean, but see, that was not handled. I mean, if Alan wants to hire them and they charge him $1, then the judge has no business in that business.
Right.
They're private counsel, and a quirk in Criminal Rule 24 is that private counsel don't have to be. Well, once again, I'm thinking it's a death penalty case. So it's not. If Alan says I paid these guys $1, I want them as my attorneys, then it's done. That's, to me. Now, if you go back and say the reason they were dismissed is because of contempt, then it doesn't matter whether they were public or private. But I don't know that's. I mean, I guess in a way you got to clarify exactly what the reasons are that they were let go. But she said gross negligence. I think that includes things other than just violating a couple of orders.
Right.
Does that make sense?
It does. So do you think that they would be let back on as pro bono, or do you think that they would be reinstated?
Well, they'd have if Alan wants them as his attorney and it says, I have hired them, then yes. I mean, a pro bono attorney is not appointed by the court.
No.
They volunteer to do it for free, but they are private. Now, they can petition the county for funds for an investigator and all that, whether you're private or not. You can say, I'm private counsel, but we don't have any money to do this, and we need the money to do this because it's essential. That might get thrown back in their face. They take that risk. But, and they're taking a risk if they jump back in and do it pro bono, knowing that they may cut them short of the funds that they need, that he needs. Don't forget, this is about him. And so if they take a step that cuts off money that Alan needs for his defense, then they have to. I mean, who are they trying to please at that point?
Right. Well, I think they seem to indicate from their rhetoric that they feel that they're the only attorneys who can help him with their Odinist theory. So I think that may be driving some of the actions on their side.
I doubt that Alan told them that he thinks it's the Odinists in Delphi that did it. Let's put it that way.
Yeah.
Yeah, I don't know. I've never seen that. Good luck. I mean, stranger things have happened. Or stranger things have been presented that have won. Let's put it that way.
Thanks so much to Mark for his great insight. We appreciate him. Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.